Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hello, and welcome to the Men's Divorce Podcast. I'm Kim Gray, and I have been with Cordell and Cordell for a little over 15 years at this point. I've been practicing family law for 20. And today I've got Russel Frank with me. And Russel, go ahead and introduce yourself.
Hi, I'm Russel Frank. I'm the Orlando office of Cordell. I've been here for about a year. I've been practicing law for about 21 years now, the last 12 of which have been exclusively in family law. And I have been trained in collaborative law as well as a certified family mediator.
Great. So that's one thing that we're going to talk about today. So it's great that you are certified in collaborative law because that's our topic for today. We are going to be talking about collaborative law. What is it? Why would people do it? And what does it benefit us? Remember, always, in order to schedule a virtual consultation, call the number below or visit cordellandcordell.com to get that set up. So let's just go ahead and get started. Russell, why don't you tell us a little bit about collaborative law? What is it?
So collaborative law is a really exciting way to practice divorce cases. When you talk about collaborative law, you're really speaking about, the parties coming together in a concerted effort to stay out of court and resolve the cases amicably. So some of the main focuses are creating what the goals are for the family, and then providing the resources to be able to meet those goals by the use of different professionals in the process.
So what are some of the benefits to doing your divorce collaboratively versus going through the court litigation process?
There's a lot of differences and a lot of benefits to the collaborative side of things. So first of all, we're talking about a team approach versus an adversarial model. So when you go into court and you're filing cases and you're litigating the cases, it's always adversarial. One party's trying to win, the other party's trying to prevent the other party from winning. In collaborative, it's a team approach. And so we try and craft it so that there's no winners and losers. We are creating shared goals that will help your family. And again, we use different professionals. So some of the other benefits are going to be the timetable at which your case moves. In collaborative law, for the most part, the case is not filed right away. You'll sign a collaborative agreement to participate in the collaborative process. And if and when that breaks down, then you could then file your action in court. So you really go on your timetable when you're using collaborative law. When you're dealing with the court process, you're really at the mercy of the judge's calendar, the other opposing counsel's calendar, trying to schedule things. In collaborative law, you can kind of schedule things as they come up, meet as often as needed to try and resolve the cases. The main benefit from using collaborative law is the use of experts to try and help assist the families as we work through these divorce cases. When we talk about experts, we're talking about maybe child counselors, maybe divorce coaches, financial experts, mortgage experts, and anyone else really that might be needed to pull in to try and help some of the issues in the case. And a lot of times the issues that we're seeing are dealing with parenting plans, the equitable distribution of marital assets and liabilities, including how to deal with marital homes. And so sometimes a mortgage or a financial expert is going to be extremely important in trying to break those things down. And the idea is that there's going to be full and fair disclosure, voluntary disclosure of all the financial records that you might need, so that there's no pulling of teeth to try and get records from the other side that sometimes happens in litigation. You'll sign the contract that basically says you guys will agree to provide the documents to each other in a timely manner, provide those to the neutral professionals so they can review those, while you each retain your own attorney to be able to protect your interests.
So you mentioned a couple times signing a contract to enter into an agreement to do collaborative law. Are there any commitments within that contract that the parties have to make in order to make the collaborative law arrangement work?
Yeah, so the commitments that you're going to make is to agree to the process. And that includes maintaining an open line of communication between all the professionals and creating sort of a pledge to work together. You want to try and reach an agreement before you even go to court. And that's the idea of the collaborative cases, is that there's no litigation involved. You try and work out the issues before you even file something. And then when you do file something, usually it's an uncontested case at that time, and you can proceed almost to an immediate final hearing.
So what are the costs of collaborative law, and how is that different from a traditional divorce?
And that's a great question, because that's one of the questions we get a lot. And in Florida, during our initial consultations, we're required to at least tell people about the collaborative option. And so one of the things they want to know is, well, how much does this cost? And generally, there's been a lot of metrics on the cost of collaborative versus traditional litigation. And so what we have found generally is that it can be a lot cheaper to go the collaborative route than a litigation route. If you're talking about a full length case, where we're talking filing cases, maybe some temporary hearings, all the discovery that's going to be required, and going to a trial, that's probably 12 to 18 months of legal fees spread out over that long period of time. And you're probably looking somewhere between $50,000 and $100,000, if not more, to litigate those types of cases. In the collaborative area, you can get those costs out in front, and you're going to have to pay different professionals at the beginning. So you may be paying your attorney, your wife may be paying her attorney. There may be a child counselor. There may be a divorce expert. There may be a financial expert that's brought in, and all these professionals would need to be paid up front. But generally, for the most part, a lot of the professionals will take those money on sort of a payment plan, and will work on getting those payments throughout the case. So without the looming threat of litigation, the cost can be significantly lower, but it requires the parties coming in with that right mentality of collaborative process of trying to make sure that we're going to work on it together and work it out to try and keep those costs down.
So do both parties still need a lawyer in order to do collaborative law?
So that is required. So each party is going to need to have an attorney that's trained in collaborative law, because it's a whole different mindset when we're talking about collaborative practice. A lot of times when we're talking about litigation, we're looking at different angles. How can we exploit this angle to our client's benefit? What documents do we need to be able to show what our client needs? In the collaborative world, you don't have to worry about those things, because you agree up front that you're going to exchange all the important information, and you're going to have your own attorney there to make sure that your interests are protected. One of the differences that I will mention in the collaborative law is that if the collaborative process breaks down, your collaborative attorney would be then forced to withdraw from the case. And then you would have to find a new attorney for the litigation part of the case. And the reason for that is fairly simple. They want to have attorneys that are invested in the collaborative process. We don't want attorneys that are just in there to try and see if we can resolve it, such as a mediation, and then back out and go right to court. The idea is that we are going to take it slow. We're going to work together and not file the motions that require us to go to court. And so if that were to happen, then the collaborative attorneys would need to withdraw, and they would have to find new attorneys.
Yeah, so that makes sense. Everybody is supposed to be committed to trying to resolve things amicably between everybody. So we don't want anybody to have an incentive to be more combative and file those motions and all of that. I can imagine that there are also some benefits regarding privacy. I mean, when you are filing something in court and you're going through a legal battle, then oftentimes it is public record. Can you talk a little bit about that and how that differs in collaborative law?
Yeah, and that's a great point. And that's important to a lot of people, to try and keep their business out of a public record. And so generally in that litigation process, you're going to be filing motions. The information that you provide in those motions, there might be allegations related to your spouse or to your minor children, and those things will be part of the public record. Through the collaborative process, since there is really no case that's being filed at this point, you can really curtail what's being filed with the court. If there's a non-litigation track that you guys are on, then it's possible you don't have to file financial affidavits with the court. You would still exchange that information within the collaborative process along with all the required financial records, but we can keep those out of the public record and really just file a settlement agreement that details how the case is being resolved. Okay.
So you mentioned, obviously, both parties having lawyers, and you mentioned some experts sometimes being involved. Is there anybody else involved? What about if there are children, are there any experts there? What are all the types of professionals that can be involved in this process?
Absolutely. So, and obviously when we're going through divorce cases and there are children involved, that's the main aspect of the case. Money will come and go. The children are going to be the most important aspect of any family law case. And so we do want to involve people that have familiarity with how to deal with divorces in children. A lot of times there's life changes that are going on, kids being split between households and things like that. And that can be emotional, it can be stressful for the children and the parents. And so a lot of times some of the professionals we'll involve are either parenting coaches, parenting coordinators that can help the parents in their decision-making process, try and find out what type of time-sharing arrangement might be best for the children. We'd also have perhaps child counselors, psychologists, psychiatrists, or just mental health counselors that are familiar working with kids in these types of situations. Because again, we want to make sure that the kids come out of this relatively unscathed. And so that's a benefit of the collaborative process, is that we're recognizing up front the importance of having these types of professionals involved to help guide you through the process.
What are some of the things a child specialist or a therapist would do to be involved in that process?
We would, everyone all the neutral professionals that are involved would be agreed upon by the parties as part of the team, and so everyone would be on board with the professionals that are going to be engaged in the process. And then what they generally do is they will generally meet with the children, and they can kind of discuss how the children are feeling, how they're doing, if there's any behavioral issues that are popping up with kids as a result of a separation within the family, they can help address those issues. And otherwise just make sure that the kids have an outlet to be able to express their concerns or their feelings. A lot of times it gets confusing for children during the course of a divorce case and their parents are separating. They don't want to upset either parent. They want to try and make sure that neither parent feels like they're being not included in their lives. And so a lot of times a counselor can help be a springboard for the child to make sure that they have an outlet to express their feelings and even communicate some things to the parents, so that the parents can understand what the children are going through in an attempt, hopefully, to make things easier for the kids.
Yeah, I mean, I think that's really important to know that when you're doing collaborative law, you can do it even if it's a little bit messy and you've got kids involved and things like that. What are some of the other issues? I mean, sometimes people come and they're getting a divorce and they've got all kinds of issues. They want to talk about alimony and maybe relocating with the child or division of parenting time and property division. Can all of those things be settled and handled in a collaborative law situation?
Absolutely. Any kind of family law case, as long as the parties are committed to the process, can be collaboratively resolved, whether that is a modification or a relocation, and even with financial issues, that can be very helpful. A lot of times when we're going through traditional litigation, each party will have to hire their own expert. If we're talking about different types of valuations on properties or vocational experts, things like that, each party is going to have to pay for their own expert. In a collaborative process, you agree that you're going to have a neutral expert that's kind of going to assist you guys through the process. And so having that is another avenue to try and save a little money, because you're agreeing that only one expert's needed versus both parties hiring their own experts. And so and that can be really helpful in an alimony type case. In a high asset case where there's a lot of different assets, a lot of different valuations, fluctuations in values of prices throughout the years and things like that, getting a financial expert can be extremely helpful to kind of break down those numbers, let you know what the ranges of the distribution of the alimony might be, so that you guys can have a better idea of what the options are. And that's really what the professionals will do, is they will lay out a series of different options. And then you guys can go through those options with your attorneys and the other professionals and find out what options are going to work best for your family.
Well, what if people are really arguing about how much money each has? Someone's hiding money and there's some allegations of that. How do you find out what the true assets are, and if someone is actually hiding money, and if so, where it is?
And that is part of the collaborative contract that each party would sign. And so the idea, again, is that the attorneys are not going to be hiding the ball. They're not going to be playing games as far as trying to not disclose certain assets. That is part of the contract that's signed, is to have an openness, a fairness, and good faith efforts to try and provide all these records in a timely manner. If if an attorney is not providing those records, or if someone's not being honest about what the assets might be, then the collaborative process is likely to fall apart.
And that's all a part of that written agreement that you discussed.
Yeah, and that's going to be important to read those agreements as any contract, because it's going to detail sort of your obligations, and your obligations are to be upfront about everything and to put everything on the table, and let the attorneys, the parties, and the experts navigate all of those issues and help bring you to a common solution.
So what happens in those difficult situations where one party is perhaps violent against the other? Maybe we have domestic violence situations. We have that often in cases, and it's something that we have to deal with. And how does that fit in when you're trying to resolve something amicably in a collaborative law situation?
And that's a good point, because unfortunately we do have to deal with the issues of domestic violence sometimes. And so as a collaborative lawyer, you have an affirmative obligation to ask your client about those types of things and make sure that there's no history of coercive or violent behavior towards the other party. If there is, then the collaborative process might not be right for this particular group. However, as the collaborative attorney, you can have a discussion with your client about it, particularly if they're the party that was the victim of the violence, and you can talk to them about whether or not they want to proceed with the process, and then whether or not the lawyer reasonably believes that we can proceed with the process in a safe manner. And so that would require the client knowing their options about the collaborative process, and getting their consent to agree to proceed with the process, even with this history. And so we've had situations before where the parties do want to collaborate and want to try and work out issues, and there may have been a history there. And so, there's different things that we can do in that regard. It's not ideal, but we can be in separate rooms, and not actually have that physical contact and have the experts kind of go from room to room. But the idea is the collaborative process needs to be a safe environment for everyone, where everyone feels that they can express themselves freely without having the other party jump down their throat or make accusations against them. And so we want to try and account for that early in the process and make sure that these aren't factors that might affect or hinder the collaborative process.
Okay. So say one is ready to start a divorce and they're interested in collaborative law. How would they get started?
So generally, during the initial consultation, we will have those discussions about what a collaborative case looks like, what the cost may look like. And if someone expresses an interest in that, generally what we'll do is we will then explain to them that, there's in our local community, there's, probably about 30 to 40 attorneys in total that just exclusively do collaborative law. And so a lot of them have good reputations for working these types of cases. And so you'd want to reach out to another attorney that you are comfortable working with, and see if they're interested in joining the case. And that's usually how the case will get started, is through one of the professionals. It could be a counselor that they go see, and the counselor recommends the collaborative process. And generally the counselor then may recommend a collaborative attorney for that person, or for both parties. But it's vitally important that there's good communication and that the professionals can work together in a productive manner. And so it is important to make sure you have a collaboratively trained attorney on both sides.
Okay. So you talk with the attorney, you make sure it's someone who's collaboratively trained, get everything going, get all the experts together, work through everything, and say that you do all of that and you come to some agreements and you guys everybody's on the same page. And what do we do then? How do we get it into an order, into a judgment signed by the judge to finally be divorced and be done with everything?
So following the conclusion of a successful collaborative case, we would have that agreement. We'd have a full marital settlement agreement. If there's children involved, we'd have a full settlement, a full parenting plan as well. So we would put those documents together and we would file them as an uncontested case. And so in the petition, we would just simply state the parties have amicably resolved the issues. we're attaching the marital settlement agreement and the parenting plan. And in Florida, once we file the case, we have to wait 21 days before we can obtain the final judgment. So we would just need to wait that time period out. And then in most counties these days, we can just send in a final judgment to the court via email or through an electronic portal. And so in these scenarios, no party ever has to even see a judge, which I know is a relief for a lot of folks who thinks that they're going to have to come in and sit in front of a judge and be asked all these questions about their personal lives and things like that. That is not going to happen in a collaborative case.
Awesome. So what are some things, some takeaways and things that people should think about when they're trying to decide, is this right for me? Just give us a few sentences about what you think people should ask themselves when they're deciding if they should do this.
And it takes a certain type of party to be able to want to participate in a collaborative process. And so some of the things you want to, think about before, going into the process is obviously, your spouse, if you guys are going to be able to communicate, if you guys are going to be able to sit in the same room, if you are going to be receptive to the advice of others, including the professionals. If there's a lot of ill will between the parties, then the collaborative process might not be right. We've had a lot of contentious cases that go through collaborative, so it can be done. It just requires the parties to kind of buy into the system as well. Not only do the attorneys have to buy in, everyone has to buy in. And that's just flipping the whole mentality of how you would normally deal with a divorce case. And it's not confrontational. There's not going to be a scenario where someone is cross-examining someone during the process. Those things don't happen. And so you want to make sure that you're able to communicate well with your spouse, that you're receptive to the advice, and that that you understand that part of the case is non-adversarial. So we're not going to be pointing fingers. We're not going to be looking back too much. We're going to be trying to focus on the future and what's forward, so that we can make sure that we're accounting for everything.
Awesome. Well, thanks, Russell. That was very informative. Lots of good information there. Again, if you want to schedule a virtual consultation, the number is below, 866-DADS-LAW, or visit CordellCordell.com and you can schedule consultations online. Thank you.
Thank you.